Omtatah brought the case. The other guys kept appealing. The constitution kept winning. Yeah. And remember where all this began. Not in a court, in a boardroom. Ladies and gentlemen, boys and girls, welcome to another episode of Katiba na Chai, the show where we read judgments, argue with them a bit, laugh where appropriate, and then explain what actually happened. Now, today's case involves a port, a procurement process, and two familiar names. One is Omtatah, and you know when Okia shows up to court with those papers, it usually means procedure somewhere has been offended. And the other is Ali Hassan Joho. And when a port and that name appear in the same story, the country has to start listening. Anyway, this story begins at the coast with a port. And ports sound boring until you remember this. Whoever controls the port controls what comes in and how fast it moves. Also, Seaport Nyungu, ni port ya coast. And who gets priority? That's not infrastructure, that's leverage. So when government agencies decide to grant a long-term concession over port operations to a private company called, Portside Freight Terminals Limited, that decision mattered. Because this was not a short contract. This was not at technical support at Musafisha Huko. No. This was long-term control of a strategic public asset. Nani, if Kenya was a house, the port is the front door. And you don't casually give out the front door keys unless you enjoy stress. Now, almost immediately, boring questions came up. These are the kind of questions that don't trend, but end careers. Was there an open competitive tender? Was there real competition? Did this follow Article 227 of the Constitution and the Public Procurement and Asset and Disposal Act? Because though these questions may sound boring, Article 227 of our Constitution is very clear. And so it says that when the state procures goods or services, the system must be fair, equitable, transparent, competitive, and cost-effective. And the thing with the Constitution, when it says something, it's not giving you advice. It's an order. And the procurement law that follows it is just as clear. So if you're handing out a major contract, especially one involving a long-term control of a public asset, you must use open competitive bidding, unless you strictly justify an exception. That's a very strict sense, okay? Strictly, not creatively, not confidently, not I feel it in my heart, I feel it in my soul. No, okay, strictly. So what raised alarms here was that the concession was structured in a way that avoided open competitive tendering. I mean, there was no genuine competition at all. There was no level playing field, and there was no transparent evaluation of multiple bidders. Basically, in this case, procurement law was followed the same way matatus follow speed limits at night. Everyone knows the rule, but not everyone respects it. The Power Act existed, but the competition was hypothetical, And that's when Omtatah steps in. And the thing with Omtatah, no one invites him. Omtatah is just the guy who's allergic to shortcuts. Some people smell money, but Omtatah smells procedure. Imefanywa vibaya, like the rock smells what's cooking. His argument was simple. You cannot bypass Article 227 and protect statute just because a project sounds strategic or profitable. Okay. Now, in public discourse, Portside Freight Terminals Limited was linked to interests associated with Joho. Whisper it. I need to pause here because the courts are not deciding Joho's guilt, innocent or character. Okay. This is not a criminal case. But once a name like Ali Hassan Joho enters the story, the temperature must rise. And the litigation gets determined. See, we don't want to get sued here at Katiba, So anyway, so Omtatah goes to court. First stop, the High Court. And the High Court looks at a procurement process and asks a very basic question. Was the law followed? And the High Court says, nah. Because awarding long-term control of port operations, not an open competitive bidding, violates first Article 227 of the Constitution and also violates any other procurement law we have in our country. Okay? So Omtatah wins. The deal loses. I mean, that seems simple. You'd think the response from Port and everyone else would be like, okay, lesson learned. No. An appeal is filed. So the case goes to the Court of Appeal. And the Court of Appeal re-examines the same process. Okay, High Court wakasema, Court of Appeal. And says essentially, yes, the High Court was right. Procurement rules are not optional, especially when public assets are involved. Omtatah wins again. Kina Port, Kina Joho, everyone else loses. I mean, at this point, a reasonable person might pause, maybe even reflect, just rethink your strategy about this issue. But no, another appeal. And this file is packed up and sent straight to the Supreme Court of Kenya. Now, this case did not arrive to the Supreme Court by accident. No. It arrived by persistence. High Court loss, appeal. Court of Appeal loss, appeal. Again. I mean, at this point, here, I was just thinking that it stopped being optimism. At this point, it was just the legal version of cardio. Stairs. By the time the Supreme Court receives the file, it has already been examined and rejected twice. See, the judges are not seeing this issue for the first time. No, they are seeing it for the last time. Because that's how Supreme Courts worked. There's nowhere beyond the Supreme Court. Now, the bench led by Deputy Chief Justice Philomena Mwilu, together with Justice Mohamed Ibrahim, Smoking Wanjala, I love that name, but they're smoking, Isaac Lenaola, and William Ouko, they focus on the core issue. Procurement is not optional. Public assets are held in trust for the people. So you're procuring on behalf of us taxpayers, And development does not excuse lawlessness. So the Supreme Court looks at the case and makes it clear. Long-term concessions over strategic public assets must attract the highest level of constitutional scrutiny. And economic promises cannot cure an unlawful process. So in plain terms, you can't keep appealing your way out of an illegal tender. Ama huyu judge atachange mind yake. Ama huyu judge atachange mind yake. Ama huyu judge atachange mind yake. Anyway, so the Supreme Court dismisses the appeal. That's a third loss. Same issue, same outcome. The procurement is cancelled. Not because development is bad, but because illegality is worse. Billions were involved, yes, but legality mattered more. And this case matters because it tells government institutions that shortcuts are expensive. It then tells private companies that proximity is not procurement. I know someone who knows someone, and then tells citizens that courts still work only if someone refuses to let go. So Omtatah brought the case. The other guys kept appealing. The constitution kept winning. Yeah. And remember where all this began. Not in a court, in a boardroom. So good people, like, subscribe, share. Because if we don't read this judgment, someone else will read our silence as permission. Till next time, this has been Katiba. Nachai.